Well, I first want to echo what Anna Singer said and thank the people who came before me. It's a very hard act to follow. They were very eloquent and very informative. But I think there's been a good setup for my talk, asking sort of what law is needed and what needs to go forward. And I completely concur, of course, with the Chief Parliamentary Ombudsman that we need legal clarification. So I'm going to try to map out why that is so. So I'm going to first start talking about Swedish law in regard to the connections between criminal law and medical law, because that is often a concern. And so I'm going to start with some basic criminal law principles, and there are two that are of great relevance for this discussion. So the first one is that they're connected. They are not two separate laws, but they are connected in two critical ways. The first is that any intervention on a person that would otherwise be criminal, so cutting into the body, removing organs, those interventions are presumed not to be punishable if they are therapeutic on three conditions. One is that they are provided by a licensed practitioner who is acting in accordance with the requirements for licensure. Number two, that the act is treating illness or injury. The preparatory works are very clear. It depends on the nature of the intervention. And three, to proceed after the patient's consent, except in very emergency situations. Now, why is that important? It's important so, for example, if a patient has an aneurysm and the question is, can I crack the patient's skull to open the skull and treat the aneurysm? Of course, that act would be a crime if another person did it, but it's done to save the person's life, to improve the health, and that is why it is considered to be consistent with the criminal law under these conditions, as I'll explain. But the second principle is important, that consent is not a defense to any otherwise unlawful killing. So that is, again, critical, that consent is technically under the criminal law not a defense. So you can see when we look at the general criminal code for murder, manslaughter, causing bodily injury or pain, or gross infliction of injury, these things are considered crimes. And so if one were to administer a drug or do an intervention that did not effectively terminate someone's life but injured the patient, that could also be of a concern. And assisting in such a criminal act or promoting it could also be a crime. And so we have had decisions from Swedish courts that have said that, in fact, the assistance by a doctor can create a situation where there's a criminal act by persons who are taking active measures in order to hasten death. But suicide is not a crime in Sweden, and so assisting someone in a suicide is also not a crime. And as has been said before, the lines between these two distinctions is not very clear. So I think in both of the key cases, the case from 1979 and 1996, the family member who was assisting the other dying put pills in the person's mouth and the patient tried to swallow. But the difference between the case where it was not considered a crime in 1996 and in 1979 is that in the earlier case, there was also an attempt to enlist a doctor to inject medication into the patient to ensure that death was hastened and that it was not simply dependent on the pills. So the distinction here turns on whether there's an active effort to assist and hasten death or whether or not you assist in suicide. But the more important distinctions come up in the context of medical law and the connections here, because we know for patient safety's sake, the primary requirement in Sweden is in Chapter 6, Section 1, Paragraph 1 of the Patient Safety Act, which says that healthcare personnel shall perform their work in accordance with this concept we call vetenskap och beprövad erfarenhet, which is quite controversial as to its full and clear meaning, but in English, the best interpretation is probably science and well-tested experience, and that you have to give expert and diligent care, designed in consultation with the patient, and the patient must be shown consideration and respect. And when clinicians deviate from these rules, there is always a possibility for suspension and for revocation of license if there's a gross ineptness with regard to patient safety, or if someone intentionally or negligently deviates from these requirements and the patient is actually harmed or the safety is implicated. So there is also, of course, a possible penalty for engaging in a criminal act. But of course, while there may be some uncertainty as to the scope of what this means, the work with regard to the Patient Safety Act is connected to the Health and Medical Services Act, which provides that healthcare includes the prevention, investigation, and treatment of disease and injury, which means that clinicians and other healthcare personnel must act in accordance with science and well-tested experience in order to prevent and treat illness. There is no authorization to hasten death. So there are other regulations. The Medicines Act, the Läkemedelslag, requires that anyone who handles medicines must ensure that they cause no harm, must give expert meticulous care. Fines or imprisonment are possible for breach of these rules. Doctors must provide narcotics with great caution, and again, there are possible penalties. And of course, under the Patientlag, we finally have a law that formalizes the requirement that patients are given information and that consent is formally obtained from the patient. So taken all together, Swedish law has several basic requirements. So healthcare personnel must perform their work in accordance with vetenskap och beprövad erfarenhet to prevent, investigate, and treat disease. And that is the limitation. There is no obligation to provide care that does not prevent or treat disease unless it's otherwise authorized by law. Healthcare personnel cannot provide medical interventions without consent. And violations of these laws where death or serious harm to a patient occurs can lead to suspension, license revocation, and punishment. I'll try to amplify some of the distinctions or gaps in this framework in a bit, but this is why the law needs to be clarified to make sure that clinicians are authorized to engage in assisted hastening of death. So I'll move to part 2, which is the connection between Swedish law and the European Convention of Human Rights. And I want to start by describing the fact that these two things are very much linked and one and the same. They are not distinct. Under the Instrument of Government, Chapter 2, Paragraph 19, the law says in Sweden, and our Instrument of Government says that no law may be adopted that contravenes Sweden's undertakings with the European Convention for the Protection of Human Rights, which means that it is Swedish law that the government and the legislature are required to make sure that legislation is consistent with the European Convention of Human Rights. And if it's not, then the Instrument of Government has been violated. And while courts in Sweden are encouraged to authorize, or are authorized to interpret Swedish law and the Instrument of Government to make sure there is no conflict. It's only in those cases where there is a conflict that cannot be avoided that there's a determination that the Instrument of Government, Swedish law, is distinct from the European Convention of Human Rights. They otherwise must be consistent. And most importantly, even if that determination were made as a matter of Swedish law, we are bound as a matter of treaty to the European Convention of Human Rights. They have a separate treaty obligation. And in fact, under the treaty, if you're familiar with the Brexit controversy, you might think of it in these terms. Article 1, we are obligated as a matter of treaty to respect human rights under the convention. Article 19, 32, and 34 authorizes the court to receive applications and to make certain decisions and judgments under the convention, and to authorize damages under Article 41, and to make sure that the judgments have binding force and to execute them. If we do not like that outcome, we have one option, and that is to denounce the convention under Article 58 and exit the Council of Europe. And for those of you who know about EU law, if we decided that we did not want to follow the convention, we would have to leave the EU. That is a requirement to be an EU member. So it would be a Brexit situation. But under the treaty, under the ECHR, there are several key principles. And I'm going to focus on the case law interpretation of these rather than their shorthand tag. So Article 2, which generally protects the right to life, actually requires Sweden and other contracting states to protect the life of persons under its jurisdiction. Article 3 means that Sweden has an obligation to prevent inhumane and degrading treatment. Article 8 requires respect for the right to consent and inclusion of family members in healthcare decisions, as I will explain in a moment. And Article 6 and 13 require a right to a judicial remedy for a violation of civil rights, Article 6, and an effective remedy for violations of the ECHR, I want to take a moment and focus on this last point because it's a very serious one. If we want to consider new legislation, Article 6 and Article 13 must be fully understood. The government has taken a position consistently in Sweden that we do not like judicial review when it comes to obligations of medical personnel and whether those personnel have violated those obligations. And even with the new Patient Act, where we recognize that patients must consent and that doctors must obtain consent, the government has taken the position that the Patient Act is not actionable in court. Now, as a matter of Swedish law, under Article 6, as a matter of the convention, Sweden, the government and the legislature cannot make the determination that it is a civil right or not a civil right for purposes of Article 6. That must be done by the highest courts in this country. That's the Högsta förvaltningsdomstolen and the Högsta domstolen. And because we don't allow that, it's very hard to get those cases in front of the high courts. It's possible perhaps there could be some advisory opinion, but without that, that means the European Court of Human Rights will decide whether or not the right to consent as Swedish law is a civil right. But if a patient in Sweden tried to sue under the Patient Act, and if our government continued to say that patients do not have a right to go to court to get review, and managed to win at the Supreme Court of Sweden that this is not a civil right for judicial review, that would only resolve the question under Swedish law. Under Article 8, you can see the right to consent is protected by the convention itself. And under Article 13, you must have an effective remedy for a violation of a right to consent under Article 8. So if the government were to win on this argument that Swedish law gives you no right to judicial remedy, we have one under the convention. And the Supreme Court of Sweden agreed with this in 2007. And it's very unfortunate when you read the preparatory works to our legislation and reports that there is no reflection of understanding or appreciation of the importance of judicial review. And when we talk about withdrawing life support from patients or any other act, as you will see, judicial review is a key component to the European Court of Human Rights saying that is consistent with the convention. So three quick examples of areas in which the court's doctrine is important to Swedish law. So we know, number one, as I said, that Sweden has an obligation to have an adequate framework in place to protect persons from death in healthcare. It's not a case-by-case situation. What the court requires is an adequate legal framework overall that has several provisions in place to make sure that patients do not die in healthcare and that can be investigated when it happens. Second, that the right to consent is protected by the ECHR and access to courts is critical. The court has made that absolutely clear that national courts must be able to review questions where consent was violated. And also the court has been clear that familial rights include interest in consent for relatives at the end of life. Removing tissues from a dead patient's body, taking an organ from a patient's body, making sure the body is delivered to the family. And these familial rights are well recognized relative to consent, even on a dead patient, as well as one who may be dying. So when we get to the Grand Chamber's most recent decision in Lambert and others versus France, in 2015, the court dealt with a case where it was actually a nurse who had been in a motorcycle accident, I think, and he had expressed to his wife, who was also a nurse, that he did not want to be held on life support. And the court said that withdrawal of life support for a person who cannot give consent is permissible under Article 2 and 8 on three conditions. Number one, there must be a legal framework in place for assuring that rights are protected in connection with the decision. Number two, the patient's wishes can be determined with family input. And number three, that judicial review is provided to halt actions where doubt exists. And so the court said, the Grand Chamber, in fact, said there was no violation in France in this specific case because the doctors had consulted with many members of the family and tried to determine what the patient's wishes were when he could not consent and gave considerable weight to the opinions of the wife and most of the family members over the ones who objected. But the second criteria, again, was that there was access to judicial review to make sure that the decision was fully and properly considered where there were questions. Okay? So when we get to assisted dying or assisted hastening of death, the European Court of Human Rights has had several cases dealing with the question of whether or not we have an obligation or a right obligation to provide assistance in dying. And the court has consistently said no. Why? Because there's no consensus among the Council of Europe states, so that is how we often determine what the rights are, looking at our idea of what a right is under the convention. And therefore, the court, in the very first case of Pretty versus the United Kingdom, said that there is a wide margin of appreciation for contracting states to decide whether or not to permit assisted dying under Article 2 and Article 8. In Haas versus Switzerland, the court in 2011 addressed a question of whether or not a person who wants to commit suicide can do it in a way that is not painful, where there's a risk of failure. And again, the court said no, there is no obligation for nations to provide that kind of assistance because of concerns of abuse, again, as well as a lack of consensus onto the scientific and moral questions that are involved. In Koch versus Germany, I think the description was described earlier, people from Germany wanting to go to Switzerland, having to go to Switzerland to die. A husband said for his wife, he wanted a right for her to die with dignity, and the court again said no. And in Nicholson versus the UK, a patient with locked-in syndrome said, well, if we don't have an obligation across the board, can we not go to a court in an individual case and get permission for me? And again, the court said, no, there is no obligation under the convention to provide that assistance. So what does that mean? Does it mean that the court would say that Sweden, like the Netherlands or Belgium, has violated the convention if we were to authorize it? Probably not. The lack of consensus as a general matter would probably prevent the court from doing that. But this does depend, the next step is whether or not we have an adequate legal framework to make sure that the rights of the patients are protected in that system. And so I'm going to just conclude with some of those deficiencies and explain why new legislation would be needed. So one of the first deficiencies, again, is a lack of a framework for full recognition of consent sufficient with Article 8. That's both in the Patientlog and in the Forskrift from Socialstyrelsen from 2011. Now, I have to say, in reading the Forskrift, Socialstyrelsen has done an incredible job of trying to make sure that there is a framework in place so that the patient has good contact with healthcare personnel to express their wishes when it comes to withdrawal of life support, to make sure that there are people in place to talk with the patient, to inform the patient, etc. Where there are gaps, clearly, is what happens when that does not occur. We still do not have legislation to govern proxy consent. If someone has clearly expressed her wishes or his wishes and has said, if I can't speak, I need my nearest and dearest to make the decision for me. We do not have rules to clarify that. And this is a severe gap in Swedish law, as well as reading the Forskrift, there seems to be considerable weight. Where's my cup? Over here. There is considerable weight in the regulations given to the physician to make the decision, the ultimate decision. The family members are given weight in the decision, but doctors are making the decisions that were described earlier. Is it time to let go? And it's not really clear that that is consistent with the convention. And again, on this point, it's very unclear what weight is given to family input. When you look at the Lambert case in withdrawal of life support, so even forgetting assisted suicide or assistance of death, these are critical questions. If you don't give considerable weight to the family saying the patient is suffering, he has told me. She has told me that she is suffering and now can't express it. And the doctor says, well, we'll give weight to the decision, but it's not your call. That may be a serious problem under the convention. There's also been no assessment in anything that I have read under Article 3, which requires prevention of inhumane and degrading treatment. So if a patient does say that she is suffering or that he is suffering, and we say, well, we don't think you're close enough to death, or make some other determination under vetenskapligt erfarenhet, and the patient's qualitative fear and anguish, the court is very clear that degrading treatment includes any forced intervention that causes the patient fear and anguish. That is a serious problem. We have not adequately investigated that in Swedish law. And again, I'm going to highlight it again, there is no judicial review formally recognized, and this is a problem. If there's a risk of error, the possibility to go to a court and get that review is critical. So I'm going to come to one last point. My colleague Kvotselem has recently defended her thesis, and you can read her work about protection of physicians for conscientious objection. It's not clear that there's an absolute requirement in every case that healthcare personnel have conscientious objections, but there has to be consideration of those requests. And so in Sweden, we have not adopted recommendations from the Council of Europe. Our fellow Nordic countries have done so. And this is a critical question as to what framework we have, not only for protecting the rights of the patients and their family members, but also the healthcare personnel. So we come back to the basic question, is it legal in Sweden? Well, as has been said, what is relatively clear, giving a patient pills and the patient swallowing those pills, herself, himself, is probably in that safer zone where suicide is not a crime, it's not a criminal act. It's not really clear, however, that it's not an abuse of the medicines regulation, that it's not an abuse of the general obligations under the Patient Safety Act, because it's not for the treatment of illness and injury and disease, and doctors are in a very gray zone when it comes to even doing assisted dying, and could be subject to suspension or other types of penalties. And then you move to the Swedish law, and again, we have serious gaps in our legal framework in terms of protecting patients in general, but certainly in terms of trying to simply adopt a framework without full consideration of the European Convention for Human Rights. So whatever the view is of the government, we have to have a more thorough investigation of European Court of Human Rights case law and jurisprudence and the framework as a whole. That's it.